The next important aspect of enforcement is the special rule regarding the place where one can institute a suit. Now, under the normal rules of the Civil Procedure Code, the suit can be instituted either in a location where the defendant resides or carries on business, or where the cause of action arises. But interestingly enough, with copyright cases of infringement, the law provides for an additional forum, and this additional forum is the place where the plaintiff resides or carries on business. The reason this has been done is again to make enforcement of intellectual property rights more effective. Basically, the plaintiff does not have to run to the place where the defendant carries on business. Moreover, in many cases, the cause of action would arise elsewhere, because the defendant, being located in Bombay, might decide to sell infringing copies of the plaintiff's IP protected work in Bombay, while the plaintiff might be running operations from Calcutta. So today, the law, by way of this provision, allows the plaintiff to sue in Calcutta in addition to Bombay, where the cause of action arises, or Bombay, where the defendant carries on business. The plaintiff can also sue in Calcutta, where he or she carries on business or resides. So this is definitely a beneficial provision and has been used quite often to expand the jurisdiction of courts and make it convenient for the plaintiff to sue the defendant. In addition to the various remedies granted to the owner of copyright for infringement, the Act also provides for a civil remedy to one who is threatened with an act of infringement allegedly to be committed by that person. So this is called a groundless threat, or a suit for groundless threat, an action for groundless threat. The provision, section 60, reads that where any person claiming to be the owner of copyright in any work by circulars, advertisements, or otherwise threatens any other person with any other legal proceedings or liability in respect of an alleged infringement of copyright, any person aggrieved thereby may, notwithstanding anything contained in so and so provision, institute a declaratory suit that the alleged infringement to which the threats related was not in fact an infringement of any legal rights of the person making such threats. So the basic message from this provision is simply this, that if a person has been accused of infringing someone's intellectual property rights, that person can institute a suit to declare that the alleged infringement which he is accused to commit is not in fact an infringement of any of the legal rights of the person who is making that threat. So the declaration can entail also a finding of no intellectual property rights at all being enjoyed by that person. However, this provision does not apply if the person making the threats has commenced with due diligence an action for infringement of the copyright claim by him. So if the moment there is a suit initiated by that person, from that moment the right to institute an action for or an action against groundless threats does not apply. The last part of our discussion on the various civil remedies deals with delivery up and ant and pillar orders. We have already seen ant and pillar orders largely in the context of general remedies in intellectual property law. Section 58 specifically deals with delivery up and says that all infringing copies of any work in which copyright subsists and all plates used or intended to be used for the production of such infringing copies shall be deemed to be the property of the owner of the copyright, who accordingly may take proceedings for the recovery of possession thereof or in respect of the conversion thereof, provided that the owner of the copyright shall not be entitled to any remedy in respect of the conversion of any infringing copies if the opponent proves that he was not aware and had no reasonable ground to believe that copyright subsisted in the work, or that he had reasonable grounds of believing that such copies or plays did not involve infringement of the copyright in any work. So the whole idea of this provision is to take further the proprietarian assumptions underlying copyright. As we already saw earlier, property absolutism and essentialism are key to at least certain conceptions of copyright, which believe that once you are the owner of copyright, it is as good as your rights in respect of what you enjoy in the physical world, like your pen or your book, where you have absolute control over what you need to do with your property. An extension of that is the fact that if somebody makes a copy of your work without your permission, an infringing copy basically, or were to use material to make such copies, then all of that will also be colored with your property. So they all basically get the stamp of the same proprietarian assumption that makes your intangible property, your creative effort, yours. The same stamp applies or extends to infringing copies of your work that have been made by others but without your permission, or material that is used to make such infringing copies. And in such case, the court has the power to also confiscate these materials and destroy them, which is a separate power. But the idea here is that the copyright owner can assert his property right and thereby recover the possession, or basically take the possession of these infringing copies and plates and so on and so forth. With this, we come to the end of the discussion on civil remedies, and we'll quickly take a look into the various criminal remedies. As we have already seen, criminal remedies place a lot of emphasis in TRIPS, at least, on the willful infringement aspect, and the same is reflected in our Copyright Act too, though some of the provisions, as already mentioned, have come or were in force from the beginning and come or predate the TRIPS provisions. So section 63 incorporates the principle of willful infringement and seeks to impose criminal liability only on those who knowingly infringe or abet the infringement of copyright. The punishment is stipulated to be anywhere between 6 months and 3 years. And it is interesting to see that the dimension of commercial versus non-commercial infringement, which we had seen in the context of TRIPS, is also factored into the sentencing under the proviso to section 63, which permits the court to go below the lower limits for both imprisonment term and fine in cases where the infringement has not been made for gain in the course of trade or business, and for adequate and special reasons that are mentioned in the judgment. Another interesting issue that has come up in the context of section 63 is whether the owner of the original copyright should come forward in a criminal action to initiate the action. In this regard, the Supreme Court has in fact pronounced in State of AP versus Nagoti Venkataramana, and has clearly held that the idea of criminalizing under section 63 for willful infringement was largely to address the threat of video piracy. And in all these cases, there is no need to trace out the owner of the copyright. The state can initiate and continue the prosecution without the owner being present. Again, as to the issue of whether the offence under section 63 is bailable or not, as is mentioned or highlighted in the material circulated, there is a fair bit of confusion. Some cases hold that it is a bailable offence, while others hold that it is not. Section 63B of the Act criminalizes the knowing use of an infringing copy of a computer program on a computer. So this provision is interesting because the use of content that is downloaded from the internet, especially private use and so on, is not criminalized in Indian law. There is nothing illegal about, or there is nothing criminal about copying files onto your hard disk via torrent and watching it in your home. You may be committing an act of reproduction and thereby technically civil infringement, but not criminal. But section 63B says that the knowing use of an infringing copy of a computer program on a computer is a criminal act, and the large part of the reason for this comes from the fact that most of these infringers are commercial entities, people who want to save on the cost of the commercial license, and therefore may be either using an illegal version altogether or a personal use version but in a computer meant for commercial purposes in their commercial place of business. Finally, we come to section 64, which vests power with the police to seize without warrant infringing copies and plates that are used for committing infringement. Such infringing copies and plates can again be handed over, and the magistrate can then order the delivery up to the copyright owner of all the copies of the work and the different plates and so on, because as we already discussed in the context of section 59, there is a proprietarian assumption here, and 58, I'm sorry. The assumption is that the property belongs to the owner of the copyright. So these are the important remedies, both civil and criminal, for enforcement of copyright, and with that we come to the end of the discussion in this module. Thank you for your patient and kind attendance.